Good morning, Chief Justices. I appear on behalf of the applicant.
Thank you.
Good morning, Chief Justice and Justices. My name is Sitole. I appear on behalf of the first respondent, the Minister of Police.
Thank you.
Good morning, Justices. Jatine Bima on behalf of the amicus.
Thank you.
The applicant, Mr. Robert McBride, who is the Executive Director of the Independent Police Investigative Directorate, was suspended pending disciplinary action by the Minister of Police in terms of the provisions of, among others, the Independent Police Investigative Directorate Act. Mr. McBride was involved in a publicly controversial investigation against Lieutenant General Dramat, then the head of the Directorate of Priority Crimes Investigation, and Major General Sabia, the provincial head of the DPCI, on the unlawful rendition of 4 Zimbabwean nationals during 2010 and 2011. An initial report recommended that General Dramat and General Sabia should be criminally charged with kidnapping and defeating the ends of justice. However, in a subsequent final report endorsed by Mr. McBride, it was recommended that no charges be brought against them, citing lack of evidence as the reason. Mr. McBride was accused of unlawfully tampering with the report. The inconsistencies between the two reports prompted the Minister to suspend Mr. McBride and initiate disciplinary proceedings against him. Disciplinary proceedings have been stayed by the Labour Court pending the outcome of this case. Mr. McBride challenged in the High Court the validity of the various provisions in terms of which the Minister had acted. The High Court emphasized that the independence of the Directorate is expressly guaranteed by Section 206, sub 6 of the Constitution. It held that this independence was not adequately protected by the relevant legislative provisions. The provisions were declared invalid to the extent of their inconsistency with the Constitution. As an interim measure, provisions of the South African Police Service Act, providing for parliamentary oversight of the removal of the head of the Directorate for Priority Crimes Investigation, were read into the IPID Act. The decisions of the Minister to suspend Mr. McBride and institute disciplinary action against him were set aside. The latter order was suspended for 30 days, allowing Parliament a short period to institute action against Mr. McBride under the provisions read in from the SAPS Act, if it so decides. All of these orders were referred to this court for confirmation. In an unanimous judgment written by Busiela AJ, this court confirms the High Court's declaration of invalidity and holds that the disputed provisions undermine the Directorate's constitutionally guaranteed independence. The court emphasizes the need to protect the Directorate from undue influence or political pressure by ensuring that appropriate mechanisms for accountability and oversight are in place. This would include, among others, security of tenure. With regard to remedy, the Minister's contention that his decisions ought to be preserved despite having been taken in terms of constitutionally invalid provisions was rejected as unsupported by law. The minister's decisions to suspend Mr. McBride and take disciplinary steps pursuant to his suspension are set aside. However, since both parties were amenable that the order setting aside the minister's decision be suspended for 30 days so that the process can be restarted with the necessary parliamentary oversight in terms of the relevant provisions of the South African Police Act, which were read into the Independent Police Investigative Directorate Act, the minister's decision to suspend Mr. McBride is preserved for 30 days only. Accordingly, the following order is granted. One, it is declared that the following provisions are invalid to the extent that they authorize the Minister of Police to suspend, take any disciplinary steps pursuant to suspension, or remove from office the Executive Director of the Independent Police Investigative Directorate. 1.1. Section 6, sub 3A and 6, sub 6 of the Independent Police Investigative Directorate Act 1 of 2011. 1.2. Section 16, capital A, sub 1, 16, capital B, 17, sub 1, and 17, sub 2 of the Public Service Act, Proclamation 103 of 1994. 1.3. Regulation 13 of the IP regulations for the operation of the Independent Police Investigative Directorate, GNR 98 of Government Gazette 35018 of 10 February 2012. 2. Parliament is directed to cure the defects in the legislation within 24 months from the date of this order. 3. Pending the correction of the defects, 3.1, Section 6, sub 6 of the Independent Police Investigative Directorate Act is to be read as providing as follows. Open quote. Subsections 17, capital D, capital A, sub 3 to 17, capital D, capital A, sub 7 of the South African Police Service Act 68 of 1995 apply to the suspension and removal of the Executive Director of IPID with changes as may be required by the context, close quote. 3.2, Sections 16, capital A, sub 1, 16, capital B, 17, sub 1, and 17, sub 2 of the Public Service Act, Proclamation 103 of 1994, and Regulation 13 of the IP regulations are declared inconsistent with Section 206, sub 6 of the Constitution, and shall not apply to the Executive Director of the Independent Police Investigative Directorate. 4. It is declared that the decision of the Minister of Police to suspend Mr. Robert McBride from his position as Executive Director of the Independent Police Investigative Directorate is invalid and is set aside. 5. The order in paragraph 4 is suspended for 30 days in order for the National Assembly and the Minister of Police, if they so choose, to exercise their powers in terms of the provisions referred to in paragraph 3.1 above. 6. It is declared that the decision of the Minister of Police to institute the disciplinary inquiry against Mr. Robert McBride, which was to commence on 21 May 2015, is invalid and is set aside. 7. The Minister of Police is directed to pay the costs of Mr. Robert McBride, including the costs of 2 counsel. I hand down the judgment.
I call the matter of Peter P. Leishing and others under the state for hearing.
Good morning, Honourable Chief Justice and Honourable Justices. H.L. Alberts for the applicant with Mr. Graneri.
Thank you, Mr. Alberts.
Good morning, Chief Justice and the Justices. I'm Spiso Kumalo. I'm for the first respondent, the state in the first instance. Thank you.
Thank you, Mr. Kumalo.
Morning, Chief Justice and other justices. I appear on behalf of the second respondent.
Guys, I don't think she can hear me. Hey, babe, can you hear me? Okay, cool.
Okay, how many minutes?
They're coming to us now. We need to get McBride.
Hold on. Yeah, we'll be ready to start. Okay, please.
Alex, can you just go grab him?
We've grabbed him twice. He says he's on his way.
I'll send Alex.
Stand by, do it.
Yeah, standing by.